Welcome to This Explainer. Today, we're doing a deep dive into the intense bureaucratic and digital labyrinth a survivor of domestic abuse literally has to navigate just to secure their own physical safety. You know, when we think about staying safe, we usually picture a heavy wooden door and a solid metal deadbolt. Just turn the lock and you're secure, right? Well, today, we are unpacking a massive stack of court filings, state protocols, and clinical records from a highly complex family law case in Allen County, Indiana. It's the Pearson v. Pearson case, and our mission here is to uncover exactly how institutional blind spots and modern technology severely complicate domestic legal battles.
We have to start with a truly shocking premise from this case. Imagine having a visible, massive goose egg hematoma, temporary loss of consciousness, and a partner who openly admits to using physical force to quiet you. Now imagine the Department of Child Services, or DCS, closing that case as unsubstantiated. It's baffling, right? How does glaring physical evidence like that not immediately trigger a protective response from the state?
Well, this exposes a massive, frankly terrifying, blind spot in the system. The agency basically interpreted a blank search result for 911 calls as absolute safety. They checked the local police database, the Spillman system, and found 0 prior domestic violence records. No record equals proof of safety to them. But they completely missed the mechanism of the abuse itself. The respondent was physically isolating Megan by confiscating her phone and her keys. She literally couldn't call 911 to create that record in the first place.
So, here is our roadmap for understanding the civil-juvenile domestic relations matrix. 1. The broken smoke detector. 2. Shifting the burden. 3. The cost of safety. 4. The digital frontline. 5. The privacy paradox. And 6. Beyond the deadbolt.
Let's jump right into part 1. The broken smoke detector, when state protocols miss the fire.
Following the strict chronological escalation of this case, we see repeated institutional gaps that span from 2024 all the way to an emergency hospitalization in early 2026. The initial child welfare assessment opened up in September of 2024. Then came another in May 2025, right after that severe head injury over a car key dispute. And despite these massive red flags, the burden of protection just kept getting shoved back onto the survivor, which eventually led to a permanent protective order in September 2025 and a really devastating emergency hospital admission in January 2026.
It's incredibly ironic because the state's structured decision-making framework actually assumed maximum vulnerability for the kids, but it totally missed the abuse against the mother. Since the 2 minor children, Navy and Jennings, were under 5, they were pre-verbal. They couldn't be interviewed as witnesses. Now, the system is designed to trigger heightened protection for non-verbal kids, but without their testimony and without a prior police paper trail, the investigation just stalled out completely. Think about it like this. The system is essentially a smoke detector that only goes off if it sees a bright red fire engine pulling up, while completely ignoring a room absolutely filled with actual smoke. When state agencies fail to recognize physical isolation and microviolence, their smoke detector is basically useless. So where does a victim turn when that happens?
That brings us perfectly to part 2, shifting the burden from public safety to private courts.
Indiana has something called the Civil Protection Order Act, which mandates forcing all these overlapping cases into one single court. Now, logically, that makes sense. They consolidate divorce, child welfare, and protective orders, so you don't end up with one judge granting weekend custody while another across town signs a restraining order. On paper, it's a great idea. But when you are a victim suddenly thrust into this multi-jurisdictional machinery, it is an incredibly dense, overwhelming matrix.
To actually speed up her proceedings, Megan had to take a massive calculated risk. She withdrew from the state's Title 4D child support program. Now, opting out of state tracking is a huge gamble for a single mother. The Title 4D program automatically triggers state and federal tax intercepts if an abuser refuses to pay support. But it is painstakingly slow, and it doesn't represent either parent in custody or property division. So her private attorneys at Myers & Wallace advised stepping away from that public system entirely, just so they could file fast, direct, emergency contempt motions in private court.
Which leads us directly into part 3. The cost of safety, the financial toll of protection.
This is the cold, hard reality. A survivor essentially has to spend thousands and thousands of dollars in private legal fees just to maintain a basic level of physical safety. Every single email, every file transfer, and every hour of hearing preparation adds up incredibly fast when you're forced to defend your family's safety against a relentless opponent.
Over $5,000.
That staggering figure represents the financial toll for just 1 month of private legal maneuvering in late 2025. And why is this absolutely crucial to understand? Because it proves that justice and physical safety in these situations are intensely gatekept by your financial resources.
And the abuser weaponized this financial control from afar. The very second they separated, he didn't even need physical proximity to exert dominance. He just stopped paying her Allstate auto insurance. This financial sabotage totally dictated her legal strategy. Because the state programs moved too slowly, she was forced to pay those exorbitant attorney fees just to ask a civil judge to step in and immediately penalize him.
Let's move on to Part 4, the digital frontline, invisible stalking and deleted emails.
This is where things get really dystopian. To combat cheap, commercially available stalkerware, victims are forced into incredibly strict digital mitigation protocols. Megan's advocates discovered that crucial strategic emails were just mysteriously vanishing from her inbox. Stalkerware isn't some super complex Hollywood hacking tool, you know? It's usually just a cheap app installed when the abuser still has physical access to the device. It hides in the background, mirroring texts, locations, and emails. To fight that, she needed a brand new clean phone, specialized authenticator apps instead of text-based codes, and she had to run strict audits for hidden email forwarding rules.
There is a massive, glaring gap in the law right here. Under Indiana code, a landlord must change physical locks within 24 to 48 hours to protect a victim. But there is absolutely no rapid legal protection for your digital life. If an abuser sets up hidden forwarding rules, they can anticipate your entire legal strategy before you even file a single motion. Securing a compromised digital life requires a massive, unguided, do-it-yourself effort by the victim.
Let's dive into Part 5, the privacy paradox, the catch-22 of legal protection.
You won't believe this contradiction. You literally have to expose your children's identities on a federal database just so out-of-state police can enforce a protective order, which directly clashes with local efforts to keep your family hidden. Locally, you have the ACR Rule 5 protocol. That hides a victim's address from the public record so the abuser can't track them down. But federally, the National Crime Information Center, the NCIC, demands that the children's full names remain completely unredacted on the order so police can verify identities across state lines. It is a terrifying tightrope to walk.
Adding insult to injury, the procedural systems demand that a victim jump through a 3-month poverty verification hoop just to afford a court-mandated safety app. Courts routinely order the use of the Our Family Wizard app for harassment-free co-parenting. But if you're financially strained, getting that user fee waived requires you to prove 90 continuous days of government assistance. These procedural systems seem built entirely to verify poverty, rather than to actually trust and protect victims.
Finally, Part 6, Beyond the Deadbolt, the Bureaucratic Labyrinth.
When Megan transitioned to representing herself, going pro se, she found out how unforgiving the system really is. A tiny clerical error, like listing her former lawyers as opposing counsel on a 2026 certificate of service, showed how quickly the bureaucracy will reset and drop a victim's legal shield. The court system runs entirely on strict notification rules. Make one tiny mistake on a form, and suddenly hearings get canceled, motions are thrown out, and your legal protection just evaporates while the bureaucracy recalibrates.
It really drives home this point. Ultimately, the survivor had to pursue specialized federal post-conviction victim training just to understand how to make the laws work for her. A physical deadbolt means absolutely nothing when your abuser can manipulate child welfare protocols, sabotage your finances from afar, and digitally stalk your inbox. You essentially have to become a federally trained expert just to orchestrate your own safety.
So I want to leave you with this final provocative thought to consider. After seeing how exhausting this multi-front war across digital systems, property law, and state agencies truly is, if the smoke detectors are broken, the financial barriers are massive, and the digital rules are essentially non-existent, is our justice system actually built to protect the average citizen? Think about that for a moment. Thank you so much for joining me on this deep dive.